Okay, so back to this whole, my customer didn't pay their bill and I just want to go saw their fence down. Let's say that I am invited back onto their property to fix a problem. And then when I leave, maybe I take some fence with me. Maybe I only take the gates, let's say, with me when I leave, and then I just don't return to put them back until they pay me. Would that be legal? Maybe I only take the gates, let's say, with me when I leave, and then I just don't return to put them back until they pay me. Would that be legal?
You likely won't pick up a criminal charge for that particular part. If you get the invitation, you're likely not going to pick up a criminal charge. Most either county attorneys or district attorneys will call that civil, that there's a civil dispute there, and you probably won't pick up any criminal charge. But you're developing in that relationship. And so just because they treated you bad doesn't mean you should treat them bad. So there's a slight disconnect in America because I think there's a business ethic that it's okay so long as we get away with it, but that's not the model. The model is to provide fast, friendly, and accurate service, serve only high quality, appetizing, wholesome food, and maintain a clean, pleasant, comfortable restaurant. That doesn't mean you didn't get gypped somewhere along the way. You might get cheated, you might get robbed along the way. But what you want to do is you're presenting your brand. And so you want to treat that person the same way that you would like to be treated, even if they don't treat you that well. I promise you that if you give, and if you've coached anything, you know that if you give more than you get, no matter what happens to you, in the end, you'll get more than you gave.
So, and you keep using this restaurant analogy. We're not in the restaurant analogy, but it still works. Think about going to McDonald's and you say, hey, my fries aren't warm. They take them back, they get you new fries, they don't ask a question. You say, you're in the drive up and you say, I didn't get the cheeseburger I ordered. They don't ask a question, they give you a cheeseburger. And in the construction world, I don't think we're so much like that. We're like, I did too give you a cheeseburger, you stole it, you ate that thing, you were extra hungry, and you're just trying to screw me out of money. That's kind of the attitude we get.
The construction world's a whole different world. Things occur on the, there's a 10th Circuit case that talks about some inappropriate language that was out in the oil field. All right, but yes, but it didn't rise to the level of discrimination. And the 10th Circuit case, this firm actually did the case, the 10th Circuit Court of Appeals said, the language that you might hear in a church or you might hear in the halls of Congress aren't necessarily the type of language that you're going to hear out in the oil field. So the construction world is a little rougher, it's a little tougher, but when you're still dealing with the customer, your policy has to be the golden rule to treat them like you'd like to be treated. That rule, that fundamental rule, will take you so far in life. You can have everything in life you want if you just help enough people get what they want. And that's basically the golden rule.
There's been a lot of times when I was in a position and things didn't work out quite the way I wanted, and it was like, are we going to go fight over this? Or, because attorneys are not free.
Right.
You're not free. And are we fighting over a $5,000 problem and we're going to spend $15,000 fighting over this $5,000 problem? Or would I just be better off to lose that little bit of money that I lost and walk away?
Walk away. And then you end that relationship with them. And you can rekindle that relationship. In Wyoming, we have small little towns. And so sometimes there's only one contractor to do a particular job for particular folks. And so you can rekindle that relationship by, when they come back to you, say, hey, look, I didn't have a very good, the last time we were together, that relationship and the way things worked, I didn't like it. And you may be blaming me and I may be blaming you, and I may be willing to go forward with you on this other relationship, but here's what the agreement's going to be and here's what it's going to look like. If you're willing to do that, and that probably is going to be more money up front, that's probably going to be terms in the contract that you didn't otherwise have there. I've got some, I represent a lot of contractors here in Natrona County, and there's one in particular that I've worked with ever since really I've started. And we've really only been in 2 lawsuits because he values his time and he values his money. And he's been cheated a couple times by people he's done work for, but he just never does work for them anymore. And so he's hugely successful. He's an electrician here in town, hugely successful, does an amazing job, and has had hardly any litigation whatsoever. And it's all about the way you treat people. Now, you can't, like a bar fight, you can't predict whether someone's going to throw a punch at you, and you can't predict whether someone's going to sue you, but you can always predict your response to them. And so your response is the key. And I'd always go back, the business rule in America should be the golden rule.
So it sounds to me like what you're saying is that everything should be done on the front side. Because the better you do on the front side of explaining the terms and conditions and who's doing what and who's responsible, the better you do at that, the less problems there are on the backside. And at least then if there are problems, a lot of those agreements spell out exactly how they're going to be. I mean, some of them will say mediation in some contracts. I mean, that's pretty typical.
Some say arbitration.
Yeah, and it talks about what law. You know, we deal with a lot of contractors all over the U.S. So what law prevails? Is it Wyoming law or is it, you know, Minnesota law if I'm working with a contractor? So we get to spell all that out up front.
But you know how it is when you got this job and you want this job. It's a big high-end money job, and you'll look past some things. You know, the fact of the laws of Texas will apply over the laws of Wyoming. That can make a big deal. That can make a big difference. And so that's an important provision that you don't care about at the time because you just want to get this deal. You want to get this deal. Well, that may have a collateral consequence or a direct consequence to you later. But you're exactly right. How you deal with those people on the front end and those relationships and how you develop that is it's the most critical thing.
It could add a ton of cost too. If I have to go to Texas every time I need to be in court or do depositions or whatever else has to happen, that makes it a big expense.
Well, and Texas lawyers cost a lot more than Wyoming lawyers.
What I look at is what is the likelihood. You know, some people there's more of a likelihood, there's more risk. So it's always that risk evaluation. How much risk is there that I'm going to get in a fight with these people? Right. We just did this in example, Phillips 66, Conoco or something like that. And we were doing an MSA and they just would not budge. It's Texas law. And, you know, what's the chances that we're going to get, I've done a lot of oil company stuff. What are the chances we're actually going to get in litigation? Right. I'm going to go do my job. They always pay their stuff. We're good.
Right. So if you were to come to me on an MSA, and an MSA stands for a Master Service Agreement, and you can think of all the big oil and gas companies that you've entered agreements with that are Master Service Agreements, they're not going to budge on those. And the term they never budge on is indemnification, the indemnification term. And nobody ever thinks about it until it comes back and smacks them. But what indemnification means, depending on what the provision says, it says that if you do something wrong and they get sued on it, this is one of the type of provisions, you're going to defend them, you're going to hire their lawyers or pay their lawyers, and you're going to indemnify them, you're going to cover the claim. Now, you're going to carry insurance so that and that's usually part of the MSA, the Master Service Agreement, that you carry insurance and you list them as an additional insured. But those big players, they're not going to change the terms of that contract. So you're forced into entering that contract because you want to do the job. And so that makes you a diplomat. So when something goes wrong, you need to be a diplomat and figure out a way for a solution so that everybody can walk away happy and you can still walk away profitable.
We talked a little bit about lien rights, and I think that's something residential contractors, some of the smaller contractors, especially people getting into business, don't really understand that. And I know that in a lot of places you have state, in almost every place that you have to get a state license, they cover lien rights extensively. And so the people that operate under the law are kind of missing out on some of that information. What are some, I mean, granted this is state specific, but what are some things that you would recommend people? Because that is a great tool for resolution.
So all of these, every topic we've talked about, it's been state specific. So for sure, you always want to talk to your own accountant and your own attorney, always. But lien rights are different in every state, but lawyers take different approaches with liens. So for example, if you were to come to me and we were to set up your business and structure it going forward, I'm not a lien guy. The reason I'm not a lien guy is because we have a lien statute that says that you improperly put a lien on a piece of property, you can get damages and attorney's fees for that. So I don't like that because it's easy to not have properly complied with the lien statute. And then all it takes is a judge to say, hey, you didn't comply with the lien statute and you have a bad lien. But I have lawyers in here that do liens all the time. They like the lien statute like you do for every reason you just said. Because when you put a lien on that property right away, it scares the property owner and they want to get that bill paid, so that lien is released. And we didn't really talk about lien releases, but when the job's over, you know, there should be some execution of lien releases. So the approach is different depending on the lawyer that you have. So what I like to do is I like to structure the agreement on the front end and then walk it through, and then we get our lien by suing them, because I know that judgment is a good lien on real property. Once I've got that judgment, that's signed by the judge, and I've got that, and then I can foreclose on that lien. I like that approach better. The reason I don't like the other approach is because there's lots of rules you have to follow in the lien statute. So you have to put notice in the contract about your ability to lien, and you have to do that exactly right. And there's different procedures and different timing in regard to the lien.
It even specifies the type font.
Yeah. And so if it's, I can barely turn my computer on. So if it requires me to hold my mouth a certain way or to do something a certain way, I always err on the side of caution and the safest approach. And the safest approach is always to walk through to the judgment.
And that's if you can't just resolve it another way, or just sometimes walk away.
Or walk
sometimes away. That best answer is just to walk away.
What oftentimes, and I know you've seen this, is I'll get a family that's building their first house, all right? And they don't really have a written contract, or the written contract's one page, and they hire this contractor. The contractor gets maybe the foundation and then doesn't do anything else and completely walks off the job. They then go hire another contractor to finish the job, but the other contractor costs what? Another $125,000. Yeah, over and above what that contractor.
He's cleaning up somebody else's mess. He knows he's got you.
Yeah, he's got you, right? Exactly. So they think when they come to me that they can sue that original contractor, and that original contractor then will cover the damage. Well, you can sue that original contractor, great. You can probably get a judgment against that original contractor, but that original contractor probably doesn't have the money to pay the judgment. If that's the way they operate business, they're not going to have a bank full of money. And they say, well, what about their commercial general liability policy? Commercial general liability policies generally don't cover workmanship. They cover negligence. So if you drop a hammer on my head on the job site and I'm the homeowner, that's negligence. But if you do poor workmanship, it's normally not covered. And intentional type torts like fraud is almost never covered on a commercial general liability contract. So lots of times that homeowner is left holding the bag, having to put a second mortgage on this piece of property to finish off the build. And so they need to be cautious when they enter into an agreement with a contractor. What's the first thing you do? The first thing I always do if I hire a contractor to do a job, I want references and I want to see pictures and I want to go to talk to people who you've done work for. But you know, if you've lived in a town, I've lived all over Wyoming, and I always tease my kids that I say, you never buy a house as soon as you move to the town, because you don't know which ones are haunted, okay? But it's not a question of haunted. You know, down in Rock Springs, they have houses that sink into the ground because of
built on top of mine.
Yeah. So, and you know, you bought this house is sunk in 3 or 4 or 5 times. You know, you need to know the lay of the environment and rent for a while and figure out what the environment's like and who the good contractors are. You'll figure that out quickly of who the good contractors are, and you want to use a reputable, bonded, insured contractor who has a good track record of doing a good job. But what do? You get what you pay for too. So make sure, you know, you check all those things out, and then if the deal seems a little too good to be true, it might be. You need to be careful. So, I mean, and you completely understand when you're the consumer, they don't really appreciate this, but the markup, okay, there's a markup. And so to you, the markup's important. To me, it's an additional fee where if I go down and buy 2x4s on a job, I might be able to get them at Home Depot less than the markup. Now, you should be able to buy in bulk though, and the markup shouldn't have really any effect on me. But lots of times I can do a lot of my own construction, and what I've found in my own life is a lot of that stuff I do myself, and it keeps the cost down. But I've made mistakes over time, and so I have better judgment because I've made so many errors. And so that's the way it is when you're a contractor. You'll make a mistake, but you won't make that mistake again. You'll make a mistake, but you won't make that mistake again. You just can't have too many costly mistakes that it puts you out of business.